Kan my hoor?
Yes, ek hoor jou. Jy my
Okay,
hoor?
goed. Ek kan jou nou hoor, ek het nou nie gehoor nie, so ek is weer in and uit, and we've got a few people here already. Thank you so much for joining us. Good morning and welcome to our live webinar. With regards to today, I'll be your host and co-hosting with me, Sarel Snyman. Good morning, my name is Jan-Hendrik Kleinans. I'm a labor law expert with Job Law, a national company of labor law specialists for employers, which will have a look at the challenges you as an employer will have to carefully consider in regarding each of the opening processes and challenges faced in each level of the imposed lockdown or lifting of the lockdown strategy. Just to familiarize you and yourself with the current forum, it's called a webinar, and I can already see there's a few people joining. We have a chat tab on your right-hand side, and I encourage you for an interactive session to ask questions as we go along, and we've got still another 4 minutes of waiting for some people to join us still. Thank you so much for having your time spent with us in carefully considering your level 4 lockdown opening up to level 3 expectations as we discuss that. I just want to welcome my co-host, Sarel Snyman. Thank you, Sarel, for joining us today, and welcome also having this conversation with us. Also to all our viewers, welcome to you.
Thank you, Jan-Hendrik. Nice to be with you guys.
Just to keep it clear, if you have any problems in disconnecting at any stage, we know there's quite a very large wage on infrastructure with regards to internet. I encourage you to hit refresh, and if that doesn't work, I want to give you the following telephone number, and you can phone Leon. Her cell phone number is 062 335 4205, or you can also email her at Leon, Leanne, at halogroup.co.za. Should you experience any difficulties in connecting or having a bad connection, or should you fall out, it's very easy just to then just reconnect or refresh. And it's great having you here. We've still got another 3 minutes of the session to start. So I just want to familiarize you with what we are busy discussing, and I will also greet you a bit later on. But thank you so much for joining us. I see there's quite a few people coming on still. And there's a lot of talk and speculation, Sarel, am I right, in having a look with regards to level 4. A lot of happenings would have happened in level 3. We've already seen a lot of those happenings already in level 4. So it's a bit interesting also to comply with those changes, and we'll see those changes in action as the president said he will implement level 3 before the end of May, which is very interesting. What are your thoughts?
Yeah, very interesting indeed. I think it couldn't have come sooner. I think we all need it. Our economy needs it, and everybody staying at home needs it. So, yeah, it couldn't have come sooner, and it's going to be, I suppose, a bit of a challenge, but it's going to be good for everybody. We're going to get back into, slowly but surely, getting back into the swing of things, and to try and get our economy right. Some challenges for employers, but I think from now on forward, it's just going to get easier and easier as we get used to all the rules and the regulations. So yeah, good thing, and good for the economy.
Absolutely, and we also see a lot of happenings with regards to schools. I hope there's a few preschools and also some school teachers also with regards to the changes happening there. And as we could see, grade 7 and grade 12 also happening, and the opening of the school there. And thank you so much for joining us. We're still waiting for a few people to join. We've got a minute left, and if you have joined us today, thank you for affording us your time having this conversation. I will run through the agenda, and we will also encourage you to have an interactive session with us, answering questions and asking questions, and we'll try our best answering them with our professional opinion. And also with regards to the end of this webinar, getting back to you and also having your email address. I hope you gave it up as you registered, so we can get back to you with regards to your questions. We want to answer all your questions. We want to do it professionally. We've got the legal team standing to assist you in any regard. We also have consultants who are waiting and eager to help you and assist you in any which way in regard you need it and you also see fit. So I think we could start. I think there's two more people. Thank you, Rihanna Zinn. She's on and she says she's quite excited to be here. We're also quite excited with the happenings. Sorrel, just to start off the webinar, let me introduce myself. My name is Jan Kleinans. I'm a labor law expert with the company Job Law, a national company of labor law specialists for employers. And we will look at the challenges you as in labor law or employer face with regards to labor law, as you carefully have to consider yourself complying to each and every of the integration processes of the phases. We got to know the imposed phases as risk-adjusted strategies. My co-host, Sarah Snyman, a labor law expert with Job Law, also a labor law specialist with regards to employers and especially for employers. Sarah, welcome to you too.
Hi, Jan, thank you very much, and thank you to everybody joining us. I really hope you guys are going to learn something today. I'll also encourage people to take part and don't be shy. Send us your questions and messages on the chat zone, and let's see how we can assist our clients and people joining us today.
Our agenda for today is the key questions we want to ask ourselves and we want to pose to you as viewers. How to get through level 4, and then obviously the outline level 3. What does that entail? We want to discuss how we are going to manage the staff without an income, which is quite challenging at this stage. And further on our agenda is also, may employees claim TERS, or the Temporary Employer Employment Relief Scheme? Can they claim themselves? What do I do if I don't need all the staff that I have employed? And should the businesses struggling consider retrenchments now, or should they rather wait? And if I do need to restructure, how do I go about it? So we'll start off this discussion and also review what has happened so nearly in the past, and we've experienced the full lock of level 5, the closed lockdown. Level 4 easing up a bit, also with a few surprises, which include level 3 eases, and what does it actually entail, and what does the risk-adjusted strategy entail? So there's a proposed amendments to the Labour Relations Act, and relating especially with regards to industrial action. And there's a few important things happening in South Africa today. So level 4 was seen as a barely ameliorated total lockdown, while I think, Sorrel, level 3 would represent at a point in which the consumer offerings restart. And level 2 would permit the interprovincial travel again, as we see level 1, sit-down restaurants reopening again and sporting facilities reopened. So what has been widely spoken about was the district-based lockdown, depending on the average cases or active cases per 100,000 people. So the announcement by the President Cyril Ramaphosa last week, Minister of Corporate Governance and Traditional Affairs, Minister Dlamini Zuma, is also expected to publish new directives with regard to relaxation of existing level 4 lockdown restrictions. So as we know, at level 4 restrictions, the rules and regulations, what is currently happening and what are permitted and what not?
Yeah, thank you. Look, at the moment, we all, just a little bit of background, come from a level 5, and we all know and understand what level 5 meant. That was basically just for essential services, not basically, was just for essential services. And so the restrictions came down to level 4, which now makes provision for what they refer to as permitted services. So obviously all the essential services is still able to operate, but what is now added is so-called permitted services. So there's a list of permitted services. Other than with the essential services, you don't need to permit as an employer or as a business. You actually need to determine yourself. We're going to have a look at the guidelines in terms of the regulations, which businesses are regarded as permitted services, and those businesses may operate. Of course, those businesses need to make sure that the employees working, in other words, in order for them to have permission to go to work and come back from work and to actually operate during business hours, to have a permit. And that is a fairly simple process. There's a Form 2 that the employer need to fill out for an employee, and that is what the employee needs with his identification with him in order to operate should somebody want to ask him for his credentials. So the permit itself, there's no permit itself. You will remember with level 5, you needed a permit through the BIS portal, but there's no such permit specifically for level 4, and I assume the same will be for level 3 and 2 and 1. So you need, as an employer, to decide yourself whether you are permitted service, and then you may operate.
We have learned late last night that we are easing into level 3. There are some expectations. We want to touch on that. And with those expectations, there has no deadline been set as of yet. Also been mentioned by government is that we'll move into level 3 lockdown before the end of May. And that also brings some challenges. One, it is not clear how the government will regulate the districts, because different districts will be on different levels. We have seen that Health Minister Willem Kiese has outlined how South Africa's new district-based lockdown will work. And he's dealt it into different economic activities with regard to major cities as Johannesburg, Tshwane, Ekurhuleni, Cape Town, the Garden Route, Nelson Mandela Bay, also Durban, and so forth. But determining a factor in deciding lockdown levels should be based, as I understand, for each and every province and district on a preparedness to care for all those who need it. And I think we want to look at that today. Are we prepared as a business? Am I, as an employer, prepared to have my people, my employees coming back to work, being safe, and can I financially support them? So there's a few level 3 permissions I want to look at. And one of those are that we've seen later than a month ago, big parts of level 3 have already been found their way into level 4. So big changes we are expecting is obviously alcohol, the use of alcohol and cigarettes. And I think the big change would be the domestic air travel as a headline in level 3. We were supposed to see all books or just educational books being sold, and all books being sold on level 3. Well, the dealers decided that all books are educational, so they're already selling that at level 4. And then level 3 was supposed to open hardware stores, and that already opened on the 1st of May. Level 3 was also the reopening for sales and car sales, but we also saw that actually happening last week as well. And then normal postal services, e-commerce, deliveries to restart, that happened on the 14th of May already. And exercise restrictions would drop, and there was also easing with regards to that being promised. So you can see a facilitating between level 3 already integrated into level 4, and which puts the president and what he proposed as a risk-based easing at a very interesting point. And level 3 and the expectation of that, what will happen with the announcement before the end of May. We can only look at a few factors like mining would be opening at 100%. I've also looked at accommodation and food services are not permitted except for quarantine essential services. And Sorrel, any of those interesting facts on level 3 that caught your eye?
Yeah, it's just the easing up of the economy. Look, I think it's sorely needed, and the sooner we get to that, the better. We need the businesses to open so that we can get the economy running. So yeah, look, obviously the strategy is one of the government, and you know, they've got clever people that figure these things out. We've got all our own views on what should and what shouldn't, and why is this open and why is that not open, and so on and so on. But at the end of the day, I think we shouldn't lose sight of the bigger picture. And the bigger picture is we're sitting with this pandemic, and we need to deal with it to the best of our ability. This is something new for everybody. So, you know, we need to deal with it the best we can. And I think they are trying their utmost best. So, yeah, looking at level 3, I really hope that it's not only certain provinces or certain districts, as you say. I hope that they really carefully consider that, because, you know, businesses actually need to open up, and we need to get this thing running. Nothing specific that's catching my eye. Schools obviously is interesting. I see that they, you know, distinguishing between which standards or which what do they call it these days? Age groups can go back to school, you know, only the matrics and so on. So it's quite interesting. It's going to be very interesting what impact that is going to have on business. It's also got a ripple effect, you know. Some people have to stay at home because they've got kids at home, you know, and then maybe now they can go back to work or the business or so on. So it's quite a ripple effect. So we'll have to wait and see, you know, where exactly level 4 is going to take us and which parts of the country is going to open up. You know, maybe let's say Cape Town or the Western Cape stays a little bit behind. I hope not, but we'll have to wait and see.
We'll also be looking into details with regards to opening of schools and preschools. What happens if one of the students actually get infected? What happens if one of the learners and also the teachers get infected? So that is quite interesting. There's already a first circular letter by the Department of Education, which I would share with you just now. So just to get back to you mentioned earlier a very interesting question and a fact as well with regards to permitted and essential services. And I can see Clint Cowan also say he's got a question in asking, how do I keep my staff on short-term or short time when we are still waiting on TERS payments for April? To date, we have only received 8 staff payouts. It's now the 20th of May. We have spent endless hours sending paperwork, sending emails, endless phone calls to the UIF. We are still waiting on TERS payments. So as we see people battling very extensively to keep business afloat and to also support business, maybe we can just skip the question with regards to TERS for just a moment. We'll get back to you now, Clint, as we just quickly want to look at essential and permitted services. So what I'm understanding by the question Clint asked is that he is a permitted service. You mentioned earlier that essential services are discussed by the Disaster Management Act of 2002 in the regulations there of section 27 subsection 2, and essential services mean the services defined in section 213. So we've got health services. We've also seen now that people with sole proprietors and providing essential goods services can also apply. But you have to comply with the Companies Intellectual Property Commission, and they've issued a permit that you're a permitted service. And like Sarah also said, you get that on Biz Portal. But with regards to people getting back to work, let's jump right into TERS. I think that is the burning point at this moment. Thank you, Clint, for also contributing with a great question. I think what he's asking, let's just break it up for also our viewers' sake here. How do I keep my staff on short time? I think he's referring to the fact that there's a temporary layoff procedure in place. Mm-hmm. They are working short time, so not the full working hours as per discussed by the Labour Relations Act and the Basic Conditions of Employment Act. So, and how do I keep them without TERS being paid out? Sorrel, what would you advise me?
Yeah, look, we need to look at, just step back a little bit and look at the basics. And when TERS is applicable, it's only applicable when the business is closed or a part of the business is closed due to COVID-19. So that's the basis, the premise of TERS. So that's where you need to start. So if your business is not closed or partially closed due to COVID-19, you can't claim. It's as simple as that. If your business is closed or partially closed, yes, then you can claim. If your business is in totality open, but you do not have enough work, and maybe that would be Clint's situation, and the employees have to work short time, they refer to it in the regulations as reduced working hours. It's essentially the same thing. Yeah, then technically speaking, it's a bit of a gray area, but in my view, you can't claim TERS then because the employees are working reduced working hours. There's a specific claim for reduced working hours. The difference is just that reduced working hours is a let's call it a normal UIF claim that comes from your employees' credits, whereas TERS is something that is a sort of a special fund, if I can put it that way, or a special scheme that is divorced from your normal UIF credits. In other words, it doesn't matter how much service the employee has, whether it's a month or 5 years, it doesn't matter. As long as the employer is registered and as long as the employee is a contributor, then the employer may claim for the employee. Whereas if it's reduced working hours, then of course it's going to depend on whether the employee actually has credits available and how long those credits are going to last him or her to claim reduced working hours. So yeah, TERS is a problem. We call it's a challenge. To say the least. There are various issues. I think we can have a whole day's discussion on TERS. If I can maybe just the biggest issue at the moment is probably foreigners, and the second one is that the difference between paying over your UIF, or your declarations on a monthly basis, paying it out directly to SARS versus directly to the UIF. If you're doing it, which most companies does, is they do it through SARS, and the problem there is that the monies are paid over, and you're doing your declarations and you do everything that you should do as an employer or a business, but then those declarations are not made to the UIF, so the UIF don't have those declarations, and that is why most employers don't get paid, and that's a problem. So that is partially your own the business's own fault, because they should have made those declarations, but most people just did not know. Most businesses just did not know. Thought that I'm doing what I must do. I'm paying the money over to a government department, SARS, which is and they are paying it over. But anyway, there's a gap there between SARS and you filing, and that's where the problem comes in.
Thank you, Sorrel. Just to jump in here, I think thank you, Clint, for also clarifying what we asked as well. Clint saying that they closed down for a month in April after lockdown. Clint, thank you. That gives us a bit more light. What happens when you talk to a bunch of lawyers is we want to stay on the terminology and strict terminology, but I understand what you mean by short time. And it's very interesting when we look at TERS, as you asked there, your question with regards to TERS, and also as Sorrel mentioned, so you have employers and employees also contributing to the UIF fund. And we need a business to close for either partially, as you did, or for a specific period. It need be 3 months or less. And then the size of the employer's workforce does not matter. It doesn't play any part, although there's a memorandum of agreement that has a specific set of rules with regards to fewer than 10 employees. But the employees must have been in the employer's employee on the 27th of March 2020 and must have suffered will suffer salaries and income lost during that. So maybe I just want to quickly go to the with regards to the value of the benefit and how does that work. Clint, maybe you've wondered as well. The benefit is determined with reference to a sliding scale, and we've learned through also implementing that it's between 38% and 60%. So how exactly that works is that, let's say for instance, the maximum cap of TERS is at this stage 17,712 Rand per month per employee. So therefore, if an employee pays 20,000 Rand per month, the employee would not receive a percentage for the 20,000 to the full percentage. He would receive a 38%, the threshold amount for the 17,712 Rand cap. So the maximum amount of the COVID TERS monthly payment will therefore be to the amount of, I made the calculation earlier, 6,730 Rand. So if an employee's salary is less than the threshold amount, for example, like 15,000 Rand, he would only receive a percentage to his or her salary. The exact percentage, you can go to the UIF website. There's a UIF calculator. We will also put that in the comments, and we can also get back to your email with regards to that. So basically, we're sitting here with the minimum amount of the benefit is 3,500 Rand, regardless of the minimum wage. That doesn't play any role as prescribed by the applicable sectoral determination or collective agreement. And then employers may supplement these benefits. So you get a TERS benefit, you may supplement it, but employees may not get their full salary plus the TERS benefit. That is very important. And the maximum that an employee may accordingly receive from UIF and the employer is 100% of his or her salary. So your question is, what if the employer paid the employee? I see one of the viewers posting, that question. Can the employer still claim the benefit? Yes, you can. The employer may claim the benefit and may retain the value of the benefit already paid to the employee. So in order to, and this is very important to all the employers now tuned in and viewing this webinar, to avoid any disputes, is recommended that the employee pay sheet, or the pay slip reflects a TERS benefit. So in case that the employee is paid the full value of the benefit or included TERS benefit, the employee is paid an amount higher than the TERS benefit, you need to say there, this is the TERS benefit plus my contribution, and that must be very clearly stipulated on their pay slips. Just to get quickly back at the questions, Clint saying, yeah, I do understand the scaling of the contributions. Great, Clint. I hope I put it clearly to you. Also, Kathleen Borland asking the question, what about when we work scheduled hours? What hours do we claim for the employee for April and then for May? And also example, do we claim to the full hours of 195? Very good question, and we encourage also employers to work in shifts, to work in different hours, and to rotate staff. Sarah, how would you go about answering that question? For instance, what happens if the scheduled hours are being worked? How do we claim TERS in that regard?
Yeah, look, obviously, if you remember, if you're claiming TERS if your employees are not working. Okay.
So it's not a TERS claim. This is an individual UIF claim,
yeah,
code 17. Am I right?
It could be a reduced working hours claim if the employees work less hours, short time as we know it, or reduced working hours as the regulations refer to it. And I just want to add, folk out there need to remember that the TERS payment is a benefit. It's not salary. It's not remuneration. Okay, so it also needs to be indicated as such on the payslip that it's a benefit. So you're not going to pay tax on that. You're not going to deduct anything. You are, as an employer, a conduit for the UIF, and you're a bank. You pay over the money that is paid from UIF to the employee, except of course if you ask the employee to take leave, or if you gave some sort of advance or a loan. That is something else. But the big picture is you can't earn more than you would have earned. That's as simple as that. So the contribution that you've made, or the payment that you've made as an employer, an advance, whatever it might be, plus what the UIF is paying out, can't be more than what the employee would normally have earned. And also, just remember, people tend to forget that the previous period, I'm saying previous period, but from 27 March to the 30th of April, it's 35 days. It's not a month. It's not a normal month. So the payment's a little bit more. So just keep that in mind. We're not sure what the next period is going to be. Probably going to be 1 May until the 31st of May, which we don't know, probably. But just take note that it was 35 days, and it does make a difference.
I see a lot of questions with regards to restructuring, and do want to get back to TERS. We've also been we came to the knowledge, obviously, through the regulations and also employers resorting under bargaining councils, Sarel, councils which have concluded collective agreements. It's very important to note that if you are structured under such a collective agreement, you may not apply for TERS benefits other than through the bargaining council. So current councils that have concluded agreements that we know of are the Electrical Bargaining Council, Textile Bargaining Council, and also the Clothing and Industry Bargaining Council. So just take note that employers resorting under bargaining councils with concluded collective agreements are not allowed to claim without going directly through the bargaining council. And we also see that in the latest Government Gazette, number 4330, we can also just post that for your benefit. So there are employees who are entitled to the COVID-19 benefits provided by the unemployment insurance during the period of lockdown from the bargaining council or entity. And if they are eligible to be paid by a bargaining council, you are not allowed to apply directly to the UIF TERS. So the parties to the bargaining council have concluded a collective agreement. I think that's the key word you need to adhere to. I know, for instance, that MIPCO at this stage have not agreed collectively, so you can bring your own TERS application. And I also want to get back to Clint. Clint, I would suggest that you contact one of the specialists. We will give you the telephone numbers in your area, and we would have the professionals follow up on your claims and also the status of your current claims. We have that facility, and we would encourage the fact that you make use of a specialized service, especially in this time. But what happens, Sarel, when my business remains closed or it's partially open? We've seen now Clint's business has been closed. Now they've opened, but working reduced hours. What happens if my business is closed? Will there be a TERS benefit or a TERS application in May?
Yes, they will. The TERS scheme is for a period of 3 months. So that effectively means at this stage from the 27th of March for 3 months. So yes, there will be a claim for May and probably for June as well, and it might well be extended as well. I don't think the consequences of this is going to last much longer than 3 months. So in all probability, well, I can't guess, but I think it probably will be extended. But for now, 3 months. So yes, May and June, of course, they'll be able to claim.
To all our viewers, thank you so much. Yes, sorry.
I just quickly want to mention that employees can actually apply themselves. If the employer, for whatever reason, actually the employers must remember they have an obligation, a legal obligation to apply. It's not I want to, I will if I feel like it or whatever. They have to apply. Okay, so if you fall under those conditions where business closed or partially closed and you can't work, you have to claim. You have to claim. So just be aware of that. But for whatever reason, if the employer is not claiming, the employees can claim themselves. There's a tab on the on the COVID-19 TERS site where an employee himself can actually claim. So be aware of that. Yeah.
We want to move, and I think Dahlia is also posting the question here that the online applications for May are not yet open. No, they're not. Dahlia, exactly right. We're also waiting for that portal to open. People want to know about the hairdresser industry. We want to touch on level 3 openings and what exactly will happen there. We will also look at Angela's question with regards to retrenchments. I think we can get into terminology and also just helping our viewers along with regard to understanding layoff, understanding short time. So you, in this specific level, as well as level 5, the hard lock phase, we had temporary layoffs as to retrenchments that we know, which is a permanent position. Temporary layoffs were introduced where you could just temporarily lay off your employer or employee with regards to the situations opening up or bettering. So that is layoffs. And then you also got to know short time as per proposal to the Basic Conditions of Employment Act. And that got proposed also by sectoral determination. And it is in your contracts, for instance, if you work short time, it's imposed as a temporary measure for a temporary period where only a limited of work time for an employee by the employer are determined. And then we get reduced working time, which we fill in as a code 17 on your individual UIF 19 applications for the temporary layoffs. But retrenchment, a whole different ballgame, and maybe we should just touch on that for a few moments. Retrenchment is a form of dismissal due to no fault of the employee. So it's very important for employers to also convey that. It's by no fault of the employee. And it's a process whereby the employer reviews a business need in order to increase profits. Also, in fact, the loss of, there's obviously losses and we want to limit losses. That's why we retrench. And also to reducing its employees. So there must be a fair process. There must be fair reasons for the decision of retrenchment. I think that is very important to understand. And there's a fair procedure. We need to make such a procedure also known to all employees. And that gets regulated by Section 189 and 189A of the Labour Relations Act. And any procedure outside that procedure is considered an unfair dismissal or unfair procedure. So the legal obligations, what are they when we go into retrenchment meetings? Sarel, thank you.
Yeah. our listeners and viewers just need to understand that the Labour Relations Act has not changed. So we have this situation where we are at the moment, but the Labour Relations actually is still the same. The process followed in terms of Section 189 is still the same. It's obviously from a practical point of view, it's different. It's not so easy just to get your employees together and have a meeting and so on and so on. So that in itself is a challenge. My view on retrenchments at the moment is that you should really consider, think about it carefully whether you want to do it now. I'm not saying that in 2 months' time is going to be a better time. It's probably not. But for a couple of practical reasons, I wouldn't suggest going to retrenchments at the moment. For one, you are restricted from a logistical point of view. So you need to have your consultation meeting either via, either via WhatsApp or telephone call or streaming or whatever the case might be, which in itself is a bit of a challenge. And then, of course, if you're going to retrench now, you have to consider you need to pay severance packages. You have to, in all probability, pay out notice because the employees are not working. So you got to consider those practical things, and that's going to make it problematic. And then, of course, from an employee perspective, at the moment we are on, as you referred to earlier, essentially a forced layoff period. Where employees don't really have a choice. They have to stay at home. If you're not a permitted service in level 4, you have to stay at home. So there's a layoff period, and they can claim now. Employees can claim, so they can claim through TERS, and it doesn't matter what their credentials are, what their credits are with UIF. So there's a benefit for them. Whereas if you retrench them now, they are dismissed, as you said, it's a form of dismissal. And yes, they can go and claim UIF, but they will have to go and claim under the normal UIF system, depending on their credits. So for me, if it's at all possible, it's not possible for everybody, for all businesses. There are circumstances. We have done a lot of retrenchments in this last couple of months. But I would say if it's at all possible, hang on a little bit and wait a little bit and until the lockdown is leveled down to 2 or 1 or where it is before you consider doing the retrenchments.
There's also answering Angela's question with regards to if retrenchments are done, must a full month's salary as severance be paid as a notice, or can a TERS payment be part of a notice? I think you've answered that in one of your previous questions. No, it is not remuneration. So you will not have a situation where you have 120,000 Rand a month remuneration and TERS only pays like 5,000 Rand. It will obviously be not a fair procedure. So at worst, it's absolutely not even possible. So that's why also my colleague here has noted that we need to fairly consider if we have the means even to engage in retrenchment talks. And if possible, the law also states that we need to exhaust all other measures, temporary layoffs, short-term. We've also talked about, Sarel, working shifts. I think you can accommodate all your staff and employees with regards to working shifts. And we encourage that as a labour law firm. And also encourage that with regards to your business.
Yeah, they actually encourage, the regulations actually encourage the working of staggered working hours, shifts. So yeah, the current 30% for those industries like manufacturing and so on, the 30%, they talk about 30% of the number of employees the employer has. Okay, so if you've got 100 employees, we're referring to 30 employees. Now, if you think about it, if you're working shifts, in my view, 30%, you can essentially then operate 60% if you do it carefully, because as long as, in my view, you don't have more than 30% of your employees on the premises at any given time, you should be fine. So that is something that you need to think about. So yeah, it's if you can do shifts, and it's not for everybody, but if you can, it's a good option to consider.
So there's also a remedy. I want to put it to you, Sarah, like we spoke about with regards to retrenchment. And it's an employee that feels he or she has been unfairly retrenched, may refer their dispute to the Commission for Conciliation, Mediation and Arbitration. And then also the dispute must refer to the bargaining council within 30 days of retrenchment. So there are facilities that you can have a look at if you are not sure, but we suggest that you post your questions within the comments block, and we want to help you as an employer understand all the risks being taken with regards to retrenchments. Also short time, we would help you also suggesting a shift based working schedule, which would also greatly help you and assist you financially. But we haven't even touched on the fact that we are busy easing into a level 3 lockdown, and level 3 being also already introduced in level 4. There's a few of the things changing, but with regards to schools, and I want to get to infections. What happens if my employee gets infected in the workplace? Can an employer dismiss an employee who has contracted the COVID-19 virus or the strand, the SARS-CoV-2 strand or strain, on the basis of medical incapacity? So the question here is, can I dismiss an employee who have contracted the virus? Now, very important to note is that the Labour Relations Act guarantees an employee the right not to be unfairly dismissed. And when we have to look at the incapacitation, you have to do a whole full incapacitation inquiry to determine if your employer or employee is incapacitated by the contraction of the virus. And that is the Code of Good Practice on the dismissal in the Code Schedule 8 of paragraph 10, which deals with ill health or injury. And that is very important to note. A lot of people are very worried that what happens if my employee gets sick. Do we need to close down? In extreme cases, there was a study being done, and also it was only 14 days a lockdown period. But as we'll see with regards to the schools, there's a whole different approach taking place. So to fire or to dismiss one of the employees who have contracted the virus in this regard is absolutely a no.
Well, no, you can't dismiss just because the employees got the virus. At the end of the day, as I said before, the Labour Relations Act hasn't changed. You still got to follow the normal procedures. If an employee is ill, whatever the illness might be, you need to investigate, and you need to gather all your information in terms of the processes in order for you to present it in an ill health inquiry. And the best way to do that would be to have an occupational therapist do an investigation, and let that person determine whether whether it is possible or probable for this employee to work further or not, and in what capacity can the employee work, and so on and so on. So ill health is not that simple, but the simple question is, you cannot discriminate, as you cannot discriminate against anybody with, let's say, HIV or AIDS. It's a similar thing. You can't discriminate. And we also shouldn't forget that myself, you, doesn't matter who out there, we all have the same risk in actually getting the virus. However, if my immune system is compromised, if I have TB or whatever it might be, or I'm older than 60, we'll maybe talk about the older than 60 part a little bit, then yeah, of course, my chances of getting seriously ill is obviously far better. But that doesn't mean I can discriminate against you just because you are in that position. So I can't say to you, look, you can't come to work because you drive you go to work in a taxi, or you stay in wherever in a place where they might believe that you're going to catch the disease much easier. So you can't do that.
60 years old.
Say again?
Oh, you are 60 years old. You just
mentioned that.
You
are 60 years old. Look, the thing about 60 years and older is there are measures that you need to take. The guidelines or the regulations are actually quite specific about it, but it just says that you need to take extra cautionary precautions or extra measures to make sure that person is safe, and that you follow the strict the strict guidelines with regards to occupational health and safety and so on. But please don't say to the employee, you can't come to work because you're older than 60. That would land you in very serious hot water.
Fadia Saleh is asking here, just to clarify, if my business is closed and all staff are working remotely, there was a salary cut in May, do we apply for UIF? And if not, is TERS or TERS as previously stated? So if you're working from home, do we apply for UIF or do we apply for TERS? If your business is closed, it really doesn't matter if you're working from home. This is a TERS application. So you would be applying for TERS, even if it's just for a period that the business closed or a section of the business that's closed. UIF is only for short working hours or reduced working time. That's an individual claimant, and those monies get paid into the employee's banking accounts. And in other words, I would suggest that you definitely do a TERS claim there, and we can assist you. Please just leave us your email address and we would gladly facilitate that for you. Carla Franz also asked, working at reduced capacity as per level 4 guidelines, can we claim from TERS only for those not working, or can we claim if we are also working the reduced hours? Let me just put it to you again, Sorrel. Working at reduced capacity as per level 4, can we claim from TERS or for those hours, or only for those not working, or can we claim if there's also reduced hours? I think you've put it plainly. Reduce hours, UIF. Those not working, the business closed, or you cannot work for any or other instance, that is a TERS claim, unless you want to add something else.
Yeah, absolutely. And just remember that the fact that you're working from home doesn't really change anything. I mean, there's other complications and things to it. But I mean, the fact is you are working remotely. So the business is not closed. So you are working. The employer, if you as an employer or business wants the employee to work from home, you've got to pay that employee. That's as simple as that. So if that employee, even if that employee is at home and the employee at home, because remember, home is now the office, all right? So if the employee works at home at reduced hours, the business has not closed. So the business is running and operating. They're working on reduced hours. So the claim, there is a claim. The claim is for reduced working hours through UIF. And then just maybe quick little other thing in terms of the home now being an office. There are responsibilities on an employer in terms of a workplace, making sure that the workplace is safe, and so on and so on and so on. So also have to keep that in mind. We have a little disclaimer that we've prepared where the employer needs to make sure that the employees working from home sign such a document so that they're aware that this is now a workplace and I need to make sure that the workplace is safe, and so forth and so forth.
We'll definitely follow up with more webinars, but if we do not by any chance get to any of your questions, please leave it in the comments block or the chat block, and we'll manage to cover those specific questions in this presentation. So please, we will send you an email with your questions. I will try and rush through as many as possible. There are a lot of questions, and I'm glad so many people joined in. But just to clarify, my business is closed, and we've handled that one. Also, the one from Gail Gerber, I want to quickly get to. So if our work is mostly site work done by a team of, let's say, 6 employees, and each team is treated like a separate unit with regards to contact with each other, then we could have more than 30% of the workforce back at work. If one of the employees is infected, then only the team he works with needs to be quarantined. Gail, yes, one thing is for certain, that definitely changes now. Level 3, we get almost 100% workforce capacity application in most of the sectors, if not all of the sectors. So you will definitely see a different change of scenery with regards to the 30% or a third workforce being implemented. You will have 100%, but your reasoning behind to facilitate the risk assessment there is very accurate. Am I right, Sorrel?
Yeah, absolutely. Sorry, I couldn't help but seeing a question there about asking whether an employee needs to employer needs to pay for internet services if an employee works from home? That's a very interesting question. Thank you, Christoph. My feeling is yes, you have to. It's an office, the employer provides the office, so yeah, you'll have to arrange with your employee, however you do that, but ultimately it's going to be the employer's responsibility. Sorry, I just missed your question. If you can just repeat your question again.
No, it's a good point, and thank you for making that as well, Sarah. So Gail's asking that if you have a 30% workforce at the moment, if one of the employees is infected, then only the team he works with obviously then needs to be quarantined. And that is a very, very good approach with regards to risk assessment. Yes, you do not quarantine your whole workforce, only the team that is immediately in contact with that specific worker, Gail. So a very, very good question. I think you've posted a very accurate answer there as well. I want to get to the question of Ryan as well. He says, if your factory space allows for more than 30% employees to return, as you can maintain safe social distancing, for example. So if your factory size is 1,000 squares and your workforce is 60, then you can easily and safely accommodate more than 18 employees at any one point at this time. You have to just remember, Ryan, you have to appoint somebody who is like a safety officer, a compliance officer, they call it in legislation, or the new Labour Relations Amendment. You have to have a compliance officer, and with every 20 employees, you have to add another one, up until 50. So we can speak about details. Just remember to keep your risk assessment at hand. You are absolutely correct in asking that question. I just maybe want to put it to you that with regards to level 3, there are a lot of businesses, especially with regards to, I see that manufacturing is at 100%. There's a lot of businesses moving up to 100%, and we can definitely specify all those businesses in level 3, which the president said we'll move to level 3 before the end of May. A lot of businesses moving up to 100% capacity in having the employees at work. So that is it's a good question, but I think we'll see the end of the 30% or the third workforce being implemented. Christoph also asked here, or is stating that my feeling is no, because the employee does not need to spend money on transport cost and more. I think both of you guys make a valid point. Obviously, Christoph, you are correct. You can negotiate. Do you need internet to work from home? That is another question. And also the facility to work from home. I think that's an agreement you and your employer can definitely discuss. And also there can be a agreement being made. I think internet is very cheap now with our service providers also coming to the table. I want to go to Linda. Sorry, Linda Besana's question. With regards to declined employees, so foreign nationals, very good terminology there. Thank you, Linda. We have submitted all relevant declarations and all UI-19's payroll information to the designated email addresses, and still no progress or feedback. Linda, can I ask you to give us your email address? We want to facilitate you professionally, and we want to assist you in that regard, and it'll be our privilege to just help you there. I know that it could be a challenge sometimes, but we've got some great people with very skilled helpers, and that could facilitate that. Gary Geye also said, yeah, and we've got like 10 minutes left. I want to touch on the schools as well, but I do want to get to all your questions. If we don't get to answer all your questions, please keep it there. Ask as many as you can still before the time ends so we can get back to that. But Gary wants to know here, if I can just find him again, if a company cannot afford severance payout in the case of retrenchment, how do you go about? That is a very, very good question.
Well, it is a problem, but it's a reality. Those employees become creditors like any other creditor, and will have to go and stand in the queue like anybody else. Yes, they have a preferential claim perhaps, but they're going to stand in the queue. So if you can't pay, you can't pay. It is what it is. So there's a legal obligation, of course, to pay. The employer has to pay. If the employer cannot pay, the employee has a right to refer a dispute and claim severance. But at the end of the day, yeah, can't say more than that. If you don't have the money to pay, you can't pay it.
Good. There's also a question here from Jandre. He says our office is partially closed and all employees are receiving a substantial pay cut, while some are working from home. Is it my understanding that TERS application must be made for those employees? For all the staff, is this correct, or must there be a multiple application, example TERS and reducing working hours? Let me just put it to you again, Sarel. So the offices are partially closed, so only a part of the business is closed. All employees are receiving a substantial pay cut, while some are working from home. It is his understanding that obviously TERS apply there, and then what happens to the rest of the guys? Do you split it up into a UIF TERS application, or do you just do a TERS application?
Well, once again, start at the beginning. Does TERS apply? If TERS apply, do TERS. If it doesn't apply, you can't. You're not allowed to. So I don't want to oversimplify it, but that is the bottom line. You need to start at the beginning. Is TERS applicable or not? Is your business closed, or is it partially closed? Number one, and number two, am I registered with the UIF? Are they contributors? If yes, then you can claim. If not, your business, then it is reduced working hours. You can have there's no reason why you cannot do both if circumstances allow for it. It might be, for instance, that a part of your business is closed. One department, your sales department or your marketing department or whatever it might be, is closed. And those people sitting at home, and they are going to claim, you can claim TERS for them. The other staff that actually works, even if they work reduced hours, you can claim reduced working hours for them. So we shouldn't overcomplicate this. You must just make a distinction of what type of application it is and then go for it.
I want to get back to one of the other questions. Then we have 9 minutes left, and I want to touch on the schools. But also this question from Beth also wants to know what happens with foreign nationals. I think a very important point that Linda made there was that foreign nationals or foreign employees also gets a benefit from TERS, also from the UIF, and that is very relevant. How to go about that, we'll email you a bit later. Then also Oliver asking, Sarel, we would like to avoid retrenchments, but work might only pick up in July. Very good question, and he wants to know now, how long can I keep my staff on layoff, and when do I have to start retrenchments? So I think the short answer, maybe you can elaborate a bit, is that you've got three options. You've got no work, no pay. You've got a temporary layoff. You've got short time. You've got so many options. As long as this pandemic is relevant, then obviously it's to know of your own doing that your employees get the short end of the stick. So it's not up to you to determine how long. So you can, for as long as you can, I think retrenchment is the very, very last option, unless you can afford retrenchment, to actually go about retrenchment, unless you want to add something to Oliver there, Sarel.
No, that sounds about right. I just quickly want to say about the foreigners. It is a problem, but it's a system problem. So if you've done your application, it's a system problem. Problem with the foreigners, they're not recognizing their passport numbers. So it's a long story, but give us a call and we'll sort it out for you. But that is the problem why foreigners are not paid.
Great. There is also a question about the hairdresser industry, which I'm not too worried about at this stage, as you can tell by my hairstyle, Dahlia. But my understanding is that level 1 would be the appropriate level for the risk alleviation there. And but as we've seen as well, we talked about it earlier as well, we're seeing level 3 restrictions already being implemented in level 4. So I wouldn't be surprised if we see a lot faster implementations with regards to risk being moved from level 3 to 2, and maybe you can start opening and doing your business there. I can just understand your frustration at this instance. So there's already been a circular, one of 2020, the guidance for childcare facilities and schools So as you heard last night on national news, that schools will be opening from the 1st of June, and that will include grade 7s to grade 12s, or just grade 7s and grade 12s, which would pose that the rest would get in the facets where other pupils will go to school. But learners who may have been exposed to a confirmed case of COVID-19, it's very interesting that those contacts are required to self-quarantine at home for 14 days, being monitored for symptoms. They may not attend school, but learners who are not contacts of the confirmed case obviously do not need to be quarantined. So in all these cases, we can look at the different bills and legislation with regards to the current situation that we face at schools. Is the approach would be that if you are not in contact, the whole school needn't close down, and the action to be taken when a case of COVID by either a learner or staff is confirmed in your childcare or your facility or your school is the following, and I want to pose that to you. We have run out of time. The childcare or educational institution will be contacted by the relevant public health officials to discuss the case, identify people to get in contact. There is a hotline you need to take down. It's 0800 029 999, and that will refer you to your relevant contact. But in worst cases, there might not even be, it might not even be that bad. There is a very likely that close contacts of a confirmed COVID-19 case are required to quarantine for 14 days and then being monitored for symptoms. If there's no symptoms, then obviously they may attend school. So learners who are not contacts of the confirmed case should not be prevented from attending school. Family and friends who have not had close contact with the original case do not need to take any precautions or make any changes to their own activities. And you will also see some reduced activities with regards to sports activities. But we can cover that in maybe the following webinar, as there's still questions from Linda Besaidenhout. I think it's a pressing situation, the youth filing the TERS. So youth filing is a portal not accessible to all since being the beginning of lockdown. I think that's part of Linda's question. How are we supposed to capture information if it's not accessible? That's a very good question, Linda. And I would suggest you just contact one of our officers and we gladly facilitate you there. We are facing challenges, but not in extremities as you put it right there. And I can understand your challenges. We would gladly assist you and help you in any regard. And I could just touch on Christoph's comment here. Will it not be better to do payouts in a form of a loan, which can be deducted from payouts at a later stage while waiting on TERS or UIF payouts?
Absolutely.
Yeah, it's a very good idea. But if you don't have the financial capacity, Christoph, that poses a challenge. But if you do, a very, very, very good idea there. Thank you also for posing that. Sorry.
Maybe just quickly touch on U-filing. U-filing, the site is there are issues with the site specific to you could register yourself on the U-filing site as an employee, as an employer, but there are issues with the U-filing site. If that person who asked that question, you're welcome to give me a call or send me an email, or we'll put those details up. I have some information for you and I can assist you there. But there's a bit of a process that you need to follow to fix up your U-filing. If you can fix up your U-filing and you have access to your account, you can sort out quite a lot of issues, especially those with regards to declarations being made to SARS and not being declared on U-filing. Anyway, so that's give me a call or send me an email. I'll try and assist you there.
Beth Howison also asked the question here. We are an ECD school and we have had no notice so far as to when and if we will be able to open. What liability do we have to take if anyone contracts the virus? I would gladly assist you in that question in the finest details. I've just studied it this morning and it's very, very interesting. So thank you for posing that questions. We are out of time at the moment. And just to close off, Sarah, thank you so much for a great session. I think we've covered on numerous issues with regards to the challenges we've been facing in level 4, easing into level 3. A lot of uncertainty, but a lot of security as well, as there are a lot of options. We've been able to make it this far. I want to encourage employers in coming up with new ideas and new plans. Christoph, that was a great session. Thank you so much for joining us. We hope to see you in the next webinar. We encourage you to ask you your questions. Please do not hesitate to ask any questions. It's our obligation and our duty to help you in a professional capacity. From my side, Jan Kleinans, thank you so much for joining us this morning.
Thank you very much, guys, and have a good day further.
So please make a note of the following website. It's www.joblaw.co.za. And also all our contact details are on there, as well as our faces. And you can contact the relevant officers for all your inquiries. We will get back to you with a recording of the webinar. If not, we'll definitely get back to you with the Q&As. All the questions you've asked with relevant answers answered by professionals. Thank you so much. And we regard your time as very, very valuable. Thank you so much for your time this morning, and we'll keep you posted with regards to our next webinar on level 3 and the differences and the excitement we face in a new South Africa with a new normal. Thank you so much for joining us.
Bye-bye, everybody.